Good morning and welcome. We're pleased to have you with us today. We have 3 cases on the morning docket, and we'll call them in the order in which they appear. Each side, whether there's one counsel or multiple counsels, has a total of 15 minutes for argument. The appellants have the right to reserve up to 5 of those minutes for rebuttal. So once you come to the podium, after you've introduced yourself, please let us know how many minutes you would like to reserve, and we will program the clock accordingly. We're very pleased to have 2 special guests in the court today. Former presiding judge of the Court of Appeals, Patsy Cottrell. Judge Cottrell, there you are. Good morning. Forgive me, it's dark. I'm not seeing. I understand you have a guest with you. Would you like to introduce your guest?
I will. This is Evelyn Bunham, who is from Paris.
Bonjour.
Bonjour. And she has finished her first year of law school in Paris. So I brought her to see the best court.
Oh, absolutely.
In practice, yes.
Well, 3 weeks ago, I was in the Latin District, and my wife and I, and we had a lovely time, and she was thrilled that we had dinner at the restaurant where they filmed Emily in Paris, and so she was just elated about that. For those who are curious and those who are not, they filmed the outside of the restaurant, but the inside of that restaurant is not near as big as the one on the TV show. So anyway, but very nice to see you. After Paris, we went down to Burgundy and Provence for a week, and so had a lovely visit. So welcome. Glad to have you with us.
Thank you.
And we're honored to have Senior Judge Don Ash with us today. Good morning, Judge Ash. I understand you have a guest. Would you like to introduce?
I do. This is Mary Martha Wilson. She just finished her first year at Belmont. She is from the faraway city of Murfreesboro.
My goodness.
Traveled far, I see.
Well, bonjour. Excuse me. Bonjour. Let me see if I get right.
But she signed up to do appellate arguments next year at Belmont. I thought no better place than to come watch.
Well, wonderful. Well, we're pleased to have 2 bright young minds with us today, and 2 seasoned bright minds as well. And the court would love to visit with all 4 of you after today's session, if your calendar permits. Are there any announcements or introductions? Hearing none, please call the first case.
Danielle, Eldredge et al. Versus Medalogix, LLC.
Good morning, Mr. Harbison.
Good morning, Your Honors. May it please the court, Jay Harbison from Neal & Harwell, here on behalf of the 8 plaintiffs who are now the appellants in this case, along with my law partner, Mr. Nathan Sanders. If I could, I'd like to reserve 4 minutes for rebuttal, please.
4 minutes, yes, sir.
Thank you. Your Honors, this case presents issues of contract interpretation. Essentially, whether the defendant, Medalogix, has the contractual right, and I want to emphasize that word, right, because that's the word that appears in the contracts, whether Medalogix has the contractual right to repurchase my client's options after they left the company voluntarily, thereby depriving them of the fruits of their hard work and in contravention of Medalogix's promises to them. We're asking this court to reverse for 3 primary reasons. First, we submit that the plain language of the options agreements does not give Medalogix any repurchase rights for voluntary departures. Second, and as Medalogix seems to somewhat concede, Delaware law cannot provide any basis for the trial court's rulings because it does not give any repurchase rights on these facts. And then third, at a minimum, we submit that these agreements are ambiguous, and parole or extrinsic evidence firmly establishes that the parties never intended any repurchase rights for voluntary departures. We also raised an issue about the implied covenant of good faith and fair dealing, although in the interest of time, I'll rest on my briefs on that issue unless the court has any specific questions. I know the court has read the briefs and is familiar with the facts, but a couple of pertinent facts that I just want to emphasize for today's argument. Of course, my clients are all former Medalogix employees, and during their tenure there, they received stock options in the form of compensation in exchange for lower annual salaries. That's in all my clients' affidavits, or declarations rather. And they did that for two reasons. One, Medalogix was a startup and it didn't have a lot of money. And secondly, so that my clients could later reap the benefits of their hard labor. Importantly, these options were perpetual, meaning they had no expiration date, and there are no restrictions on when they could be exercised. Again, while my clients worked at Medalogix, they were repeatedly promised by company executives that their options were theirs to keep, and the company did not have repurchase rights.
Your plain language argument centers on the idea that any right that might exist under the option to repurchase falls under B Romanet 1.
Correct.
But if you look at Romanet 3, it contemplates circumstances outside Romanet 1 where repurchase may take place. Why would that be if the right only exists within Romanet 1?
Certainly, Your Honor, and I can go ahead and jump to where I was going to get. So I think that, first of all, I think if you read paragraph B3 in the way that the trial court did and the way that Medalogix suggests here, I think it creates an irreconcilable conflict with B1 and B2, which of course should be resolved in our favor under the canons of construction, extrinsic evidence, et cetera. But I think there is a way to read paragraph B3 in a way to give effect to all of its provisions, and I'm happy to explain. B1 says, and I'm starting at the very beginning here, upon receipt of written notice of death or disability of the participant. Then I'm paraphrasing, the company can repurchase, quote, in accordance with paragraphs 2 and 3 immediately below. So I don't think you ever even, I think there's a way to read this, that you don't even get to B2 or B3 unless there is first written notice of death or disability. Again, B1 at the beginning, very first sentence of that paragraph, upon receipt of written notice of death or disability. So I think, and that it's undisputed, that never happened here. None of my clients are dead, none are disabled, there's never written notice of any of these things. So the analysis can stop there. There are no repurchase rights. But then to go straight to your question, Judge McBrayer, if there is written notice of death or disability, B3 then tells us what the price will be. If the person who is dead or disabled voluntarily resigned, the price is fair market value. If the person who is dead or disabled committed a violation event, the price is cost. And so I think that written notice of death or disability, I don't want to call it a condition precedent because I don't think that's what it is.
Doesn't that make it surpluses? I mean, so there's no circumstance, what your argument is there's no circumstance under which that language would be triggered. In other words,
on these facts.
On any facts. I mean, what would be a circumstance where the company would have the right to repurchase for a reason, and I'm looking for a reason not described in section I of this paragraph, Roman 1 of this paragraph. I mean, by your rationale, there's no circumstance under when that would happen.
I think it's hard for me to come up with a hypothetical. I would agree. I've been trying to do that myself. Your Honor, you mentioned the word surplusage, and I think that is a possibility here. I think that is one way the court could rule in our favor, is to find that there is some surplusage in this agreement.
But, I mean, aren't we tasked with trying to give every word in a contract effect here? And if we do that, we're not, I mean, if we say that surplusage, we're not doing that. We're just saying, well, it was in there for no reason whatsoever.
I don't know if I'd go so far as say no reason whatsoever. I think if we compare, the 7 of my clients' agreements to that of Miss Danielle Hicks, I think we did a good job in the briefing of pointing out how hers is slightly different. We said in our briefs, I think that it was possibly a drafting error. Medalogix came back in response and said there's no proof of that, which is a fair argument. But one thing that I didn't get to earlier, Your Honors, is we never got any discovery on this ever. We are here on a motion for summary judgment, although it's that is the technical procedural posture that we're here, but it's really much more like a Rule 12 motion to dismiss.
Well, when you argue drafting error, let me ask you then about the second sentence in Romanet B1 then. That's the one that triggers the provision of the Delaware Limited Liability Company Act.
Correct.
And says that upon termination, they become an assignee. What's that all about?
Well, Your Honor, I think that what we said in the briefs and what I think is correct is when you read that Delaware statute, which is fairly long, it only mentions assignees in a couple of places. And what it says is that assignees can have ownership rights of the equity in the company, but not governance rights. And so I think that's what that sentence means. I'm pretty sure we articulated this in our briefs, which makes logical sense to me.
Well, isn't that true, though, in any circumstance? What the Limited Liability Company Act does is it divides membership interest into distribution rights and then the overall right. And what that provision stands for, I think, is you get to pick your partners in
Correct.
LLC. So it's all well and good to assign distribution rights, but you can't say, I'm going to pick someone to replace me as a member. You've got to have a sign-off on other members, unless your operating agreement provides otherwise. So what purpose does that sentence serve then?
I think we're saying the same thing, Your Honor. I think what that sentence says is that if you leave the company voluntarily, Medalogix, I think what it shows is Medalogix doesn't want its former employees out there in the wind somewhere having governance rights over the company, which again makes perfect logical sense. Talking about Delaware law, I've only got a few minutes left. I do want to touch on the Delaware law issue. The parties do dispute a little bit whether the trial court, used Delaware law solely to find repurchase rights, or whether it was, I think, Medalogix's brief said, dicta marshaled to support that holding. I don't think that whether it's one or the other really matters, because on these facts, that Delaware statute cannot possibly apply to my clients. First of all, it's the only way that you could get there for Denise Hicks, because her agreement is different for reasons that I've explained in my brief. But the Delaware law at issue, the repurchase right in Delaware law is in Section E of that statute. I think it's 18702E. Only applies to members or managers of the LLC. That's where the statutory repurchase right in Delaware law lies. None of my clients were members or managers of Medalogix at the time of this repurchase. So that statutory Delaware repurchase right can't possibly apply to my clients. It just, by operation of law and by the words of the statute itself. There's other reasons that we put in our brief for why it doesn't apply, such as I don't think that the parties would have indirectly created a repurchase right with a reference to a different Delaware subsection of that statute. It just doesn't make a lot of sense to me.
And with regard to the Delaware law, in your reply brief, you suggest that the defendant has waived that issue by not responding to your argument in your principal brief.
Correct, Your Honor. There's nothing in Medalogix's brief responding to essentially our primary argument on Delaware law that it only applies to members and managers of the LLC. Again, I don't see how that could possibly be an independent basis, let alone even support the trial court's finding of repurchase rights. I just don't think that Delaware law can possibly apply.
But in a nutshell, your argument is B1 is the only provision that gives Medalogix a right to repurchase, and in this case, that's limited to employees who died or qualified for the disability.
Correct, or for Ms. Hicks, commission of a violation event. That's what's one way in which her agreement is slightly different.
So beyond that, Medalogix does not have a right to repurchase.
Correct, and if you look at the language of the contracts themselves, that word "right," which again I would really like to stress to the court this morning, appears in B1 and it appears in B2. It does not appear in B3.
If the court were to agree with you on that point, where does that leave us in this case?
Well, I think if the court says that the plain language, because we made two arguments, right, essentially. We think that the plain language gets us there. We also think that in the alternative, the contract would be ambiguous. I see I'm running out of time. If I can finish.
You may finish.
I think a remand is necessary regardless of which way, if the court rules in our favor, of course, whether it does it on the language itself or finds an ambiguity, which I think there is an ambiguity here. I think there's an irreconcilable conflict. We would need a remand. We need discovery, first of all. Again, we never got discovery on this issue ever. And we would also like to have a trial.
All right. Thank you.
Thank you, Your Honors.
Thank you, sir. Good morning, Mr. Bowen.
Good morning. May it please the court. Jim Bowen, the Nashville Bar for appellee Medalogix. I think I want to start with Your Honor's question about the language, because I think the language controls. And fundamentally, I think B1 states death or disability creates a bad right. We all agree on that. What the plaintiffs or appellants argue is that B3, all of it, including whether it's a buyout for a termination for cause or without cause, company has no rights. They argue that B3 creates a pricing mechanism, but not a right, a pricing mechanism for a right that doesn't exist. They call it a drafting error. They call it lots of things, but what they don't do is ever give it any effect. And what we think the court below did correctly is give all of B3 effect, read them together. To Your Honor's question, it creates 3 separate rights.
Well, before you go to your next thought, the paragraph starts with, upon receipt of written notice of death or disability, the company shall have the right to repurchase all or any portion of each of the granted units. The second sentence says, additionally, upon termination for any cause, the participant shall become an assignee within the meaning of the Delaware law.
Yes.
Nowhere in the second sentence does it have the words, shall have the right to repurchase.
Correct.
So where do we jump to the right to repurchase for termination for any reason?
If you go to B3, the first sentence of B3 says, any repurchase of granted units shall be consummated by giving a unit repurchase notice. That's defined term in B2, to the point that the plaintiffs made that B2 only applies up, it actually applies down. The first sentence says, any repurchase, you give that notice.
But any repurchase should be an agreed upon repurchase as opposed to a right to repurchase.
Well, so I'm getting to point 2 to Your Honor's question.
All right.
Unless otherwise expressly provided in an employment or similar agreement, repurchase of granted units shall be made, and it gives 2 scenarios. One, if you've become an assignee who's committed a violation of that. So that refers up to number 1. If you've done this cause, if you've done something bad, and you've been terminated for cause.
And that does not apply to any of these plaintiffs.
That doesn't apply to any, but under plaintiff's theory, importantly, this also has no effect. All this language would be surplusage. They say even if there's a cause and you've become an assignee under A, we still can't do anything. And that's important because the way, and I don't mean this disrespectfully, but I mean it as a sort of an analogy, what plaintiffs want to do is sort of say these are basically lottery tickets. And they have the right, no matter what happens, by virtue of the fact they were early employees, to free ride, if you will, to use the economic term, to sit and wait. None of these plaintiffs ever exercised their right to purchase this stock. None of them ever paid the purchase price. And wait until one day, if the company hits, if something happens and it gains value.
That's an equitable argument.
It is.
I mean, let's stick with the language.
Sure.
I mean, you know, maybe that's what you're contracted to allow them to do in order to incentivize them to join at a reduced salary or, you know, whatever they were going to pay them.
Yes. And
so to the presiding judge's question, though, where, I mean, one way to read this, I guess, is that there's only a right, you can only require repurchase under the limited circumstances in Romanet 1, and that if there is any agreed repurchase, then the terms are set. Isn't that another way to read that?
I don't understand the agreed repurchase because what I read B3 to say is that repurchase shall be made. It creates a right. It doesn't use the word, it says shall be made. Gives the right to the company. One, if there's become an assignee or there's been a violation event, which prevents, if you compete, you don't get to hold the options if you get terminated for cause. And then B, in respect of anyone who's died, disabled, or whose employment's been terminated for any reason not described in Section 1. And that's what the lower court found and what we found. That's termination without cause. The only event not described in Section 1, other than a cause event, other than death and disability, is a termination without cause. And so the way to read these together is B3 is sort of the catch-all.
So you read termination for any reason to mean someone quitting, for example?
Yes, resignation or termination without cause. Any kind of termination that's not because of death, that's not because of disability, and that's not because of cause. And if it's death or disability, Section 3 and 1 read together say you get fair market value. If it's for cause termination, you get purchased at cost.
Do you have an explanation which the second sentence of Romanet 1 does here? What does it do?
It creates the mechanism by which the company exercises its right. And it refers up to, if you want to exercise under B1, if you want to purchase somebody because they've died or been disabled, you send a repurchase notice. And it defines that term. But then in the first section of B3, it says, if any repurchase, i.e. including the ones we're about to talk about in the next sentence, you also send a, quote, incentive units repurchase holder note, which is number 2. So it effectively creates the mechanism and defines the term. The reference is again made in the first sentence of 3, which is important. The notice that's given is defined in 2, but it applies up to a death or disability repurchase and down to a termination for cause or without cause repurchase.
I mean, what's the point, though, of saying the participant shall become an assignee under the Delaware Limited Liability Company Act?
Because this is the option agreement. It's contemplated the employees would write a check to exercise the shares. If you're an owner of the shares under the Delaware law and you've done a cause event, so you're competing with the company, as Mr. Harbison noted, you become an assignee, meaning you no longer have governance rights. Under the Delaware law, you become only a holder of financial rights. But that's why B3 references assignees. For those people who've done something, have created a cause event, become an assignee, we can repurchase the shares for cost, because that's B3A. It refers to the assignee, and this is important on the Delaware law issue. What the court found, it's important, this contract, this is the grant of the option, this unit option holder agreement in the record. That's a contract that's defined under Tennessee law, but it incorporates and says it is trumped by, to the extent there's any conflict, the operating agreement. This is a Delaware company. The equity that's been granted here is defined and governed by Delaware law and the Delaware statute. The Delaware statute says, and it says that any Delaware company retains the right at all times to repurchase its own equity unless they waive that right in the operating agreement. That right is not waived in this operating agreement. And so what the court below found, and what we've argued, is she didn't rely on this reference to 18702 to create some Delaware right. What she said is, no, this contract incorporates Delaware law. The equity we're talking about is governed by Delaware law.
That 702E that the court latched onto, that's a non-uniform provision?
That's the Delaware LLC Act provision.
Okay. So but it's non-uniform? It's not part of the revised uniform?
No, it is part of it, I believe.
It is?
Yeah, it's the governing statute that's referred to as the Act in the operating agreement.
Well, I understand that, but there's a revised Uniform Limited Liability Company Act that was put together by the National Commissioner of Uniform State Laws. That E is not in that.
No, this is a reference to the Delaware law,
Right.
the Delaware
so
code.
Delaware is unique. And the Delaware provision E, there seems to be a disconnect between what that provision says and the place that these participants, the plaintiffs here, are in before exercising the option. I mean, they are not members or managers, correct?
Only because they did not want to pay the exercise price. They never paid. They controlled that, and that's one of they've argued is
Well, isn't that what option agreements do?
It is, but
they give them
they
an
wanted-
option to exercise it under the conditions of the
Correct,
option.
and so we have the right to repurchase the underlying equity, though. If they don't want to exercise the right to buy it, and we paid for the equity, we paid them 69 cents a share, which is what everybody, there's no dispute that that was the fair market value. Remember down below in the trial court, she actually denied they had a claim that we repurchased at an unfair price. We didn't buy it at fair market value. She denied summary judgment on that motion in the trial court. They took discovery and non-suited those claims. So there's no issue that we repurchased at fair market value. The record contains all kinds of evidence to that effect. But one of the issues they've argued is, hey, you aren't allowed to, the operating agreement amended over time. And they have argued that the board doesn't have discretion to interpret these agreements, exercise these agreements under the operating agreement because it had been amended over their objection. And one of their arguments is we should have been allowed. Well, that only allows only members get to vote on amendments. Those who were members, there were two plaintiffs here who were members, who both voted approving these amendments, who both sold all their shares voluntarily when they had a chance. But this idea that Delaware law doesn't allow the company to repurchase its own equity, or in this case, the underlying equity.
So were these membership, I don't know that I know the answer to this question, but membership interests, were they issued by the LLC and just held as like treasury membership interest and waiting for the potential that these options might be exercised? Is that how they were?
They called them Class B units, so they had.
Right, so there are two classes, A and B here, I understand that, but does the membership or operating agreement provide that if upon the exercise of an option, then the membership interest is created for the purpose of satisfying that option, or how does that work mechanically?
I believe they're profit interest, and so these are basically, technically they're not really, they're technically not options. They are basically restricted stock, restricted interest, Class B interest, where they vest over time and they can pay a repurchase price, and they can pay a purchase price and get the shares. None of them ever purchased the shares. If you read the agreement at the first page, it actually says the units are granted subject to payment of a purchase price. None of the holders actually ever purchased the equity. And that's one of the, technically what we did is we repurchased the equity at the price, less what they owed. So the price was 69 cents. Everyone owned for between 69 cents to $1 to repurchase. None of them had ever actually paid that. So they owned these Class B units, but they never had been granted them technically. They never bought them. They had the right to buy them. They never bought them. So while we call it option because it's colloquial, technically these were grants of profit interest subject to payment of a purchase price, none of which the plaintiffs ever paid because they didn't think it was worth it. But the Delaware law, this is important, reference to Delaware law is because the operating agreement and the option agreement all say the rights and the interest of the equity are governed by Delaware law. The equity is governed by Delaware law. The operating agreement refers specifically to the Act. The Act says the company at all times maintains the right to repurchase its own equity. And what the court said is that supports my finding that the parties, under the plain language, created 3 buyout mechanisms with different prices depending on the circumstances. A low price if you do something that's cause, and fair market value if you die or disabled or terminate for cause. And while it's equitable, Your Honor, the point of that, the business rationale is the parties didn't want these to be lottery tickets. These were incentive options. It's called an incentive option agreement, because it's to the employees to incent them to work hard and create value. 10 years later, with 3 different ownership changes, an entirely different management team, these folks who worked for in 2012 to 2016 shouldn't be rewarded for the efforts of others. They were repurchased at fair market value for the efforts in their labor. To Mr. Harpeson's point, they were getting stock.
Yeah, well, so we're getting back into equity here.
Correct.
I'm more concerned about what the contract says.
Right.
And I mean, where I am struggling here is it looks like there's sentences missing from Romanet 1. That they started with one scenario and then left out intervening scenarios except to say, and I still don't understand this provision, they became assignees under 702 of the Delaware Act, when that would have been true no matter what, once they exercise the option, right? I mean, that's the default rule in Delaware, 702.
If I may answer your question, if I may answer, I know
Yes.
I'm out of time. The assignee provision only kicks in for a violation event. None of these folks became assignees by virtue of terminating. They remained option holders, and unless
And
until we
that's what I don't
repurchase.
make sense. Why would you want to make a violator an assignee of financial rights? The default already is when someone acquires a membership interest, they become an assignee under 702. That's the default rule. That's what it's all about.
Because well, that's two answers. One, I think they retain both unless this is to make clear that if you do a violation event, become an assignee, you don't have any governance interest to the extent you might. But the bigger point is, and that's why you go down to B3. B3 says if you do that bad thing and become triggered as an assignee, we have the right to buy you out at cost.
And you're saying that's under E.
That's under B3.
Okay, so you're not relying on the statute there.
No, that's B3.
And the statute doesn't create a right to
It doesn't
purchase.
create-
It just says the LLC may repurchase it.
Correct. And that's why B3, so there's two provisions of B3, and they want to focus on B1 and they want to focus on the termination without cause. But it also addresses to your honor's question, if there's a violation event and you become an assignee, you immediately under B1 lose your governance rights to the extent you have, and you become a, quote, assignee. We also immediately, whether we exercise it on day 1, day 5, or day 365, have the right to buy you out at cost. And under their provision, we don't have that right to buy them out at cost, and B3A has to be struck. Similarly, B3B has to be struck, and that's our point. All these work together. While it is not the most artfully drafted agreement, there are three separate scenarios. And with that, Your Honor, I know I'm out of time.
Well, before you go, if I understand your brief correctly, your position is that the Delaware Act really isn't applicable in this case, and that the trial court's reference to the Delaware Act was just reference for explanatory purposes, but the trial court didn't rely upon the Delaware Act. Is that correct?
Yes and no. With respect to everybody but Ms. Hicks,
Okay.
our position is she relied, as she said, on the plain language, and the Delaware Act, she said, this is consistent with the Delaware Act where the company retains the right to repurchase its own equity. So I'm not doing anything radical here. These two line up. With respect to Ms. Hicks, I admit she sits differently. The language of B3B about a termination without cause, the repurchase, that is not in her agreement, and what the trial court found there is under the Delaware Act, specifically 702E, the company retains the right to repurchase her equity absent some provision in the operating agreement that says otherwise. And under the operating agreement, they gave themselves discretion to make this determination. And so she, with respect to Ms. Hicks, did rely on the Delaware Act. I will acknowledge she sits differently. We've always argued she sits differently. But with respect to Ms. Hicks, Your Honor, I think the court did rely on the Delaware Act.
All right, thank you. All right. We'll hear from Mr. Harbison on rebuttal, and since we gave Mr. Bowen extra time, Ms. Bogus, would you give Mr. Harbison 7 minutes instead of 4?
Oh, goodness.
Thank you.
Try not to use all that time, Your Honors.
You can save it for another argument.
Next time. I want to, Mr. Bowen talked a lot about how, the fact that, and we don't dispute this, that my clients never exercised these options, and that is true. But there's a good and logical reason for that. First, as I said in my opening argument, these options don't expire. They're limitless. And so when the repurchase was made in 2019, when Medalogix made this purported repurchase in May of 2019, which also, as pointed out in our briefs, was just weeks before the company got a huge outside equity investment. The timing on that, talking about the equities, Judge McBrayer, to me is highly suspect. The options were always under, what Medalogix said in May of 2019 is these options are underwater. you can exercise them at 79 cents or $1, but the company's only worth 69 cents a share, so therefore we don't owe you any money. No money was ever changed hands here between anyone. I want to make that very clear. So why would my clients have exercised these limitless options when the company was underwater? Why would I pay 79 cents or $1 to receive shares of a company that are only worth 69 cents? There would be no reason for me to ever do that. Additionally, and we touched on this in the brief, eventually what happened is it was not the outside investment shortly after the May 2019 repurchase. I think it was a year or two later in 2021. I apologize, I don't have the date exactly right, but that doesn't matter. There was what was referred to in the documents as a liquidity event, meaning that a majority purchase. And so what happens under the operating agreements when there's a liquidity event is all of these options are cashed out, and the company buys them all back. So what my clients were doing was working towards building this company and selling it. And when that happens, they get to cash out. And that is, in fact, what did happen after the company, supposedly repurchased them. I want to go back to some of the plain language arguments that we were talking about earlier. If you read B3 in the way that they suggest, I do not see how that completely nullifies the first sentence of B1, upon receipt of written notice of death or disability. Again, that is something that never happened here. Judge McBrayer, you talked about missing terms, and I think that certainly one way to read these contracts is that there are missing terms. Again, to go back to what I was saying earlier, when you compare theirs to Ms. Hicks's, there are some, you can see some copy and paste, what appears to be copying and pasting going on.
Yeah, so what do we do? And we didn't get this in your original argument. What do we do with Ms. Hicks then? Where, B1, but Romanet 1 has that language. So what happens there?
For me, Mr. Bone didn't go that far, nor would I if I were him. But I think reversal is required for Ms. Hicks, no matter what this court does with the rest of my clients. The right simply isn't there for her, and the Delaware law can't possibly apply to her. I would also mention, there is a line in paragraph G of these agreements that says that they shall be construed according to the laws of Tennessee without reference to principles of conflict of law. So that's another kind of wonky and difficult thing to reconcile within these agreements when you have that definitional reference to Delaware law in B1.
And if Delaware law does apply, it's limited to this one section because of the designation of Tennessee law applies.
That's the argument that we've made. And in our principal brief, we talked about how it's I think we called it a limited definitional reference. And we cited cases from Tennessee and elsewhere that say you can incorporate part of a statute or part of a document into a contract without bringing in the whole thing. And that's what I think that second sentence of B1 does, is it makes them assignees under certain circumstances, but it doesn't bring in the statutory repurchase right in 702E. I just don't see how that really fits. It doesn't make a lot of sense to me.
Well, one way it could fit is you could say, to the extent that it had been exercised, they certainly would be assignees, and this would be alerting the participant, look, you're gonna be able to exercise this, but you need to understand that we're just talking about distribution rights here of a member, not management rights. Yeah,
right.
Not government.
If they had exercised them, I think that is one way that it could be construed.
But back to Ms. Hicks' situation, why wouldn't the company, it says, shall have the right to purchase all investment Class B common units of the participant. Why wouldn't that trigger their right in Ms. Hicks's case?
Which paragraph of Ms. Hicks are you looking at?
I'm looking at
Romanet
Romanet 1.
Okay.
Of Ms. Hicks's agreement.
And I apologize. I don't have it in front of me.
Okay.
Again, for Ms. Hicks, I just don't think the argument for Ms. Hicks primarily to me is that her B1 is different, but her B3 is also different, and there is no. Again, we're saying that B3 is just a pricing mechanism.
Right.
There is no pricing mechanism in B3.
So, okay.
Does that make sense?
Even though it says at a purchase price of a penny a unit.
That's for unvested options, I believe,
Right,
for
it is.
hers.
It's unvested.
And so, here, to be clear, we're only talking about the options that vested.
Yeah, okay.
So for her unvested options, they're supposed to pay her a penny, which, by the way, they didn't do. Again, Judge McBrayer, to answer a question that arose a minute ago, I don't believe that about the Delaware Act. Best I can tell, there is no statutory repurchase right in Tennessee. You were talking about the Uniform Act and things like that. I've not found anything comparable to that subsection E in Tennessee law.
And to your knowledge, subsection E, the Delaware Act, is not part of the Uniform Act. So we can't go to comments to try to figure out what Delaware was thinking when they adopted it.
I don't know if it is a part of the Uniform Act or not.
Well, I mean, it strikes me, I mean, and you can correct me if I'm wrong here, Delaware Act, what this agreement seems to rely a lot on, wants to make the operating agreement the be-all and end-all.
Certainly.
So we want to let members contract however they want to in that operating agreement to control the company. So doesn't that send us a message about how we should read these provisions?
I'm not sure if it does. I mean, especially again when they say these contracts are supposed to be governed by the laws of Tennessee. I don't think you're even supposed to get to E at all.
Well, but aside from E, I mean, I'm not sure E does anything in this case, but the agreements do incorporate by reference the terms of the operating agreement.
Yes.
Do they not? And so, and I appreciate there's a distinction, or there's a dispute between the parties about what operating agreement governs, but still, the operating agreement is part of the terms here, so we've got to read that as a component of how we interpret these.
I agree. Best to my knowledge and best that I've been able to tell, the operating agreements are silent as to repurchase rights. Yeah. So I think that hopefully that answers the court's question. Again, in the 30 seconds I have left here, Judge McBrayer, you're talking about missing terms. Again, I was talking about that a minute ago. I mean, I think that's something that we would like to have some discovery on, frankly. How did these agreements come to be? Who drafted them? I mean, we know Medalogix did, but I don't, was never allowed to take any depositions. I've never gotten any documents related to them. I haven't seen the other ones. I think that may, shed light on what the intent behind these is, because presumably there are other agreements for other former employees. I see that I'm over. I apologize, Your Honors. We ask this court reverse. Thank you.
Thank you, Mr. Harbison and Mr. Bowen, for your arguments on this very clear and straightforward issue. We may assign this case to a special panel of Cottrell and Ash, if y'all don't mind.
I like that idea.
Yeah, okay, very good. All right, thank you very much. Call the next case, please.
Kenneth R. Bird Jr. versus Christopher Michael Ritchie et al.